the record. So good afternoon, everyone. My name is Kostas. I'm from the Hellenic Mediterranean University. I'm very happy to be with us, to have with us Mr. Stratis Koulierakis and my friend Rafael, of course. It's a great pleasure to have Stratis with us. He's going to speak in something completely different, but very, I will say, hot regarding today about the data protection in the era of the digitalization of education. So the exact title of today's presentation is Engineering Data Protection Law into the Design of Digital Education. Stratis is now he works in the very famous in one of the most prestigious institutes in Europe, at least, but in the world, I would say, University of Groningen in Netherlands. His first degree is law, if I am not doing mistake, but I will give the floor to Stratis later on. And nowadays he's performing his PhD in a topic that he's going to reveal very shortly. So Stratis, thank you very much, not only you, but also my colleague Katerina Bobolaki for the introduction. So the floor is yours in order to start your presentation. As I mentioned, Engineering Data Protection Law into the Design of Digital Education. Something very important since now the education is moving to a hybrid mode. So we have this online version for inclusivity as well into our system. Thank you, Stratis, and the floor is yours.
Thank you so much for the introduction, Professor Petridis, and I'm very happy that you invited me, and also I would like to thank Ms. Bobolaki for the reference. So let me share my screen now. Is it now the correct screen? Because I was confused. All right, perfect. So thank you again for the introduction. And as you mentioned, I'm in Groningen in the Netherlands, which is a very picturesque city. It's the northernmost city in the Netherlands. And it has also some nice modern architecture. And notably, it has a very vibrant academic community and a very vibrant student community. People at the faculty board would be very happy to hear all those kind of words from you, Professor. And also, I imagine that's also because they have a very good physics faculty, a very well-known one. So, but I work in the Faculty of Law. My background is law. I'm a lawyer. And I'm doing my PhD. However, I'm in a research group, which is called STEP. My work is supervised by Professor Mifsud Bonici and Dr. Milay Weishar. And STEP is a group that brings in together lawyers and people from the technology sector, and we all together study issues of law and technology. So we really have an approach that requires that lawyers have familiarized with technology aspects. And in specific, my project is funded by Horizon 2020, Marie Sklodowska-Curie Actions. And the project is called KnowGraphs. It explores knowledge graphs, which is a means of representing knowledge in a machine-readable format. And my topic is data protection by design in knowledge graphs. So today I picked a specific aspect of my PhD dissertation, which is data protection by design. And I will present this legal provision, and we will subsequently see how it fits within the modern framework of technology. We will see some practical implications. So today, first I will present the overarching framework of data protection. I will try to refer to some practical examples, such as ChatGPT, in order to explain why data protection law is such a necessity nowadays. Then I will make some general remarks about data protection law in the European Union and the so-called GDPR, the General Data Protection Regulation. Then I will discuss in particular about data protection by design, which is the topic of the presentation, and we will see a few practical examples of this general idea in the domain of education, and in the end, I'll wrap up everything. So already in the 60s, there were some very brilliant scholars and some legal scholars who noticed the proliferation of digital files about individuals. And with the emergence of computers, we started having vast databases in corporations and governments with any kind of information concerning natural persons. And moreover, the interconnection of those databases, of course, with the connection of internet and the emergence of computation power, led to the practical ability to combine data from multiple sources. This way, even seemingly harmless information about the everyday life of individuals, let's say shopping habits or geolocation data, might reveal very intimate aspects about their lives. Moreover, as long as we have those vast databases, we have security concerns about data leaks or hacking. And people were already discussing about the proliferation of data about individuals already in the 60s, but nowadays we are facing this reality every day. The collection of data really reached a new scale with the invention of wearable devices and the installation of built-in cameras on every device that we use. Moreover, even more recently, the widespread use of artificial intelligence led to a situation where we have algorithms which are fed with personal data, and subsequently, they are evaluating persons and they are issuing judgments on persons which might affect their lives. For example, credit scoring is an issue where we have algorithms which might receive personal data and evaluate the credibility of a person. So the problem in that regard is that the use of artificial intelligence algorithms sometimes is not transparent even to the creator of the algorithm. And this is what leads us to what some authors call the black box society, a society where we have algorithms which are issuing decisions about persons without us really understanding what is going on in there. And another example I would like to mention at this point is ChatGPT. This technological innovation, again, brings in some data protection considerations. And I'm mentioning it because it is a very illustrative example. So it stores the user's activities, and it's a nice illustration of what we call informational asymmetries. So we have a very big conglomerate, a very big enterprise on the one hand, and on the other end, we have users. The enterprise is able to collect and store the prompts by the users. They might even use them in the future. They might profile the users. And on the other side of the spectrum, we have a user which is not able to negotiate, of course, with ChatGPT, and is not aware of what is happening with their data. So the informational asymmetry is this relation in law and in economics, where you have one party which knows everything about the consumer and a consumer who is unable to make changes there. And also from a developer who uses ChatGPT in order to debug their software, to somebody who uses ChatGPT to write a poem for their significant other, we see that the history of the prompts that we use in ChatGPT might reveal many aspects of our life. So again, this is an illustrative example why we need personal data protection nowadays. So it's not to sound technophobic, but I'm mentioning these examples as the overarching framework. So what are the considerations that brought us to have this framework that I will present now? Before going into the GDPR, let me say for a moment that the European Union now prepares a new act, the so-called AI Act, which wants to address AI comprehensively, even in occasions where they do not process personal data. But this is still a draft. It has not been passed as a law yet. So let's focus for today's talk on the General Data Protection Regulation. It is about data protection law in the European Union, where it is what I'm discussing today. In outside of Europe, you might come across the terms privacy or privacy, I don't know the correct pronunciation. But in European Union, we refer to this idea as data protection law. And the most important piece of legislation is the GDPR, the General Data Protection Regulation, which defines personal data as any information relating to an identified or identifiable natural person. So we have a very broad definition here. It includes shopping history, biomedical data, and it includes any kind of information regardless of how intimate it is. If you go, for example, to a hotel and they store maybe what somebody ate in the hotel, this constitutes personal data. And the system of the GDPR is as follows. We have the data controller, who is the mind behind the processing, who is the one who determines the means of processing, and the data subject. And in a nutshell, the data controller has responsibilities and is the one who bears the responsibility for data protection law. And the data subject is the one who needs protection and who has some rights. An important clarification at this point. The characterization of a piece of information as personal data does not mean that its processing is prohibited. So the GDPR is not here to prohibit personal data processing. It's about regulating personal data processing. So if I say that X piece of information is personal data, it doesn't mean that I cannot share it or process it or do analytics and some other things. It means that there are some applicable rules. We need to look into the rules to see what is going on. And I mention that because sometimes lawyers or people in the domain of biomedical research, they are afraid of when, for example, they might have some databases, they really do not want to admit that they process personal data because they intuitively think that if we say it's personal data, then we should not process it, which is not true. There are, however, some rules. At times, they might be burdensome or they might be strict, but there are some rules which allow us to process. So we have some general principles. I will come to that in a moment. We also need a legal basis. So the GDPR says that if you want to process personal data, you need to refer to some specific reasons for which you're allowed to process. The consent of the data subject is one example. Legitimate interest of the controller is another example. So the idea is controller on the one hand and data subject on the other hand. And then we have the data subject rights that we need to respect. We have the right to erasure and rectification. So the data subject might request the deletion of their data in some occasions, to make corrections. If they have some inaccurate data, they might be able to access their data in other occasions. The right to object is the idea that the data subject might want to object to a very particular aspect of data processing. So for example, if somebody has my contact details and they spam me all the time with emails, the right to object would be, let's say, I want to receive less emails. So these are the data subject rights. And in addition, we have multiple safeguards. And here we come to the gist of today's talk. One of the safeguards is this idea that data controllers need to comply with data protection law by design. And what Article 25 of the GDPR tells us is that data controllers need to adopt technical and organizational measures in order to engineer data protection rules into digital applications, hence the title of today's presentation. So it's this idea that we need to take the legal rules and to inscribe them into digital applications. This might sound a bit superficial, but let me give you an example. So this is not data protection law, but it is very illustrative. So the University of Groningen last year underwent was affected by the rise in the price of energy, as all Europe. So what they decided was that to adopt a policy that says you should not switch temperature above 19 degrees. One way of achieving it is to issue an email to every member of the personnel saying, guys, do not turn up heating above 19 degrees. That's the rule. But the university could adjust all the heating systems in a way that it does not allow us to go above 19 degrees. So this is an example of how you can implement a legal rule into the system. In the domain of data protection law, imagine, let's say, a hospital. The doctor who is responsible for a patient should be able to have a look at his file. But on the other hand, a nurse should not have access to that particular directory in this example. So instead of just telling them who has access to what, if the files are digital, they can implement access control policies which allow only the authorized personnel to have access to specific files. So this is the idea of engineering legal rules into the design of digital applications. And let's see how this applies in practice. So for example, I'm going back to the case of ChatGPT. According to the GDPR, when a digital application is likely to be accessed by children, the data controllers need to do some checks in order to know the age of the user, because there are specific rules applicable to the personal data of children. So you have this duty to confirm the age of the data subject. When ChatGPT was first implemented, they had no mechanism for some kind of age check. And this led to the Italian Data Protection Authority to issue a temporary ban of the application in Italy. So this eventually this measure was lifted because they implemented some kind of age check in Italy. But this is a nice example of a data protection rule. Do some age check, and then data protection by design requires you to adopt a mechanism. A small parenthesis here. For example, there have been artificial intelligence tools developed which monitor patterns in the user's behavior that they can approximate the age of the user. And let's proceed now to the domain of education. As you might remember, during the COVID pandemic, the schools in Greece were closed. And what happened back then was that the Greek government decided to implement a distance learning tool based on Cisco WebEx. And now we see some examples here of data protection by design in the domain of education. The case of Cisco WebEx went before the Greek Data Protection Authority, where they found a violation of the GDPR and Article 25 GDPR in particular. So the problem for them was, number one, that there were no identification checks from the system to ensure that the ones who access the system are actually the students. So this was a measure that was missing. We can imagine that if some user somehow gets hands on an account, they might see what is going on in a class, they might collect data of the students, and this brings us to the initial thoughts that the digitalization comes with some risks that need to be prevented. So what the Data Protection Authority in Greece said in that case is that they needed to have some kind of identification mechanism. Moreover, they underlined that the personnel, as well as students, they should have gone through training and information campaign for the use of the software. So, for example, again, the software could be installed in home devices with cameras, and students had to be aware of the challenges in that domain. For example, that other students could see their house, they could hear private conversations in their house. So that was another important idea, that data protection rules should, the students and the personnel should have been educated with data protection rules. And subsequently, let me see. So having all those general ideas in mind, let's see what are some measures that we can implement in the domain of digital education. So again, the GDPR is not about prohibiting the processing of personal data, but it is rather about regulating it. And then we have some very fundamental principles pertaining to personal data processing. So we have one principle, which is data minimization. According to that principle, we should limit the processing of personal data only to the information that it is necessary for a particular purpose. So as we said, and to make a connection to the general framework that I started about the proliferation of information about the users and connection of data from different sources, what the EU requires is that when we process personal data, we only limit it to what it is necessary. In the domain of education, this principle, for example, in digital education, could be implemented. One measure could be to switch off cameras during breaks, as there is no, if, for example, in a conference or at university lectures, if we have a hybrid format, then the camera might capture an intimate conversation during the break. Moreover, we have another principle of data protection law, which is the principle of storage limitation, which requires that the data need to be stored for only the period of time that it is necessary. This means, in the domain of education, that we need some kind of policies for how long we need what kind of data. And that's not, it might be any kind of personal data, such as presence of students, for example. So what the principle of storage limitation tells us is that we need to have a predetermined idea of how long we should store them and to delete the unnecessary data after a period. And in that regard, in my studies, I'm looking into official documents where they put down measures of compliance with the GDPR. And I see more and more the idea that software companies should develop systems for automatic deletion. So you set the idea that we set a default period for the storage of the data, which if we need it for further time, we can then go and declare a longer period. But that's another example. Then we have integrity and confidentiality. That is another very important aspect in the domain of data protection law. So, for example, we have a rule that tells us that only authorized personnel should access the files. We should prevent hacking attacks or data leaks. In the University of Groningen, for example, we started implementing two-stage authentication for the logging into the system of the university, which I think in the state-of-the-art standards, they require it more and more. This idea that we should not have a naive login system, but this two-stage authentication. So these are some examples of data protection by design. And let me tell you at this point that this is not an exhaustive list of measures that we should implement or that at all instances we need to have these particular measures. Those examples that I mentioned here is that I took a domain that we are all familiar. I gave some concrete examples in order to show that because of the big challenges that arise from technological innovation, we need to develop a mindset for the protection of personal data at multiple instances. And And this leads me to the conclusions, which is that we should not have a technophobia, but it is necessary that we are constantly concerned with the ideas of data protection. Because in this world where we have emerging risks from artificial intelligence and the proliferation of digital files of individuals, we need to have this mindset where we are up to date with risk and challenges of data protection, and we are constantly in a process of finding solutions in that regard. And this concludes the presentation.
Thank you very much, Stratis, for the presentation. Personally, I have a couple of questions because I think I'm naive. We are doing so many online sessions, but personally, I'm naive how compliant I'm with the law. But I would like to give the floor to the participants if they have any questions, to start, or I can start with my naive questions, if this is okay. Let me introduce you also my colleagues from Israel, Dr. Elena Mistrahi. I follow the order of my screen, just to be politically correct, and Dr. Samia Zaid from Western Galilee College. And also we have partners, from Morocco. I can see here, it's very relevant to our project, which is like the impact concerns a lot of online sessions. And I think that this kind of, let's say even tips is very important for us. And I say that probably we should create our, policy within the project, something that we have not predicted, until now. Probably it's a nice idea for a new project. That's Stratis, you can collaborate with the University of Groningen and you. So let me start with a question. First of all, I have my first question. Who can be the data controller in the university? This is my first question. For example, I will give you, I'm creating my Moodle platform and I have all the data. I know the students. I know how the students, they behave. I can even develop a prediction model in order, to tailor, to facilitate their learning in this case. But who can be the data controller? What are the qualifications in the university? Who has this role?
So, yeah, that's a very nice question. I forgot to mention that. So, a data controller can be a natural person like me and you, or a legal person or a legal entity. What in Greece, the one who has legal personality is the university. But so in principle, it is the university who is the data controller, but it also depends on the degree of freedom that you have within there. Because if it is a very independent research center, even if they are not typically registered with a legal personality, if they have a high degree of maneuver, they might be data controllers themselves, research centers, for example, and so on. In the case of high schools and in Greece, it was the case was brought in the Cisco WebEx case. The case was brought against the Ministry of Education, and they were ordered to comply with the law. And then but it's important to have in mind that data protection law also allows us to have more than one controllers. So, for example, if we use Zoom, for example, Zoom stores our data, so they need to do their own homework and comply with the law. And if you are using it for hybrid lessons and so on, there are also some obligations for the university, for example.
So I mean, in this case, the law or the services, they don't demand some specific competencies for this person that acts as a data controller? Or they depend that I'm not going to share the data, I'm not going to reveal the names. What is the situation? I mean,
it's a bit factual. So if the university has a very established policy for and about how you should use their data, it's them who determine the means of processing. But if a member of the personnel um, takes a directory and starts doing things of their own with beyond the policy of the university, then they are in charge of their own. Then they become controllers. They might be compliant or not, but again, if they take the responsibility themselves, they become controllers.
and my second question is the following. I mean, in this case right now, I'm recording the session, okay? And I'm going to share then the YouTube, the recording file through our YouTube channel. And I have the option through the YouTube channel, this video to be viewed, only for those that they have the links, which means those that they have registered to this seminar or those that they have registered to our course, or, to share this with anyone in YouTube. So in order, to in the projects, in order, to increase the views and the visibility of the project, usually you select, to be viewed by anyone in the YouTube. In this case, I suspect that I'm illegal because I'm sharing your faces, your names with anyone in the web. Am I right?
As far as I'm concerned, I'm okay with it. But
if you're okay, I'm okay. Because I
I'm
thought that I will be in prison, very
But
soon.
some teachers don't like the idea. We ask at the Western Galilee College, we ask our students the teachers to send recordings or they listen to their students, but some teachers don't like this idea. They have to send the recordings, but they're not happy about it.
But they are not happy because of their performance or because of the law?
Because of the law.
Because
privacy.
of the law.
Yeah.
Yeah. So in this case, I suspect that I like the idea of Stratis that he mentioned that GDPR is a regulator framework that does not prohibit, the use of personal data, but on how to use them. Am I right?
Yes, but there are cases where you might say that you cannot. There are things you cannot do. This is for sure. But I wanted to say it's a different thing, like this consortium that we are here and we're discussing, which is like going to the television. Okay, it's.
I like this.
Yes.
I like it.
And you can have also some kind of privacy notice that explains to the participants that, look, this is going to be broadcasted. You are participating in order to be broadcasted. And it's another thing inside your working space to put a camera. So it's not that I'm working here. It's not that all my life is under surveillance. So Professor Samia Zaid mentioned?
Correct.
Yes. It's way more intrusive to put it inside the class and to have them under constant surveillance. I cannot know always to have an opinion about the legality of how it works in Israel or in other European universities with those cameras, but no matter what, when a camera goes into those everyday activities of the universities, it's good to have some ideas in mind, like why are we recording those data, how long we should keep this data, let's switch off the cameras during the breaks, or let's give some privacy notices to the personnel to know when they are monitored, where they are not monitored. That's the idea, I think, behind. But no, yeah, I cannot know exactly how it works with the regulations of each and every university about monitoring.
I would say that, in the case of Samir, it's not a part of a regulation. It's a part of how individuals, we have the same in Europe, not everyone would like to share the video. It's how do you perceive and what you would like to do, I will say, to be honest. Samia? You would like to say
Yes.
something?
Yes,
Please.
I didn't. Sorry, I joined this meeting late. I was in home, but I have a question. Like, there were two issues this semester. One, maybe Ilana, I don't know, you can elaborate on that. We're sharing our data with we wanted to purchase digital platforms, and Lena, we wanted, like, at the college to purchase platforms, and we shared our data. And at the end of the year, the subscription were renewed using our data that we shared for 1 year. So that was an issue. Another issue we had this year is that we use digital platforms in our classes and our courses. And every year we are asked to send our students' names, full names, with their ID numbers. And we just do it. And I don't think it's right to do it because these companies ask for the really personal details of the students, their full name, the ID numbers, in order to create accounts for them. And I don't know whether I'm invading our students' privacy. I don't know what to think about it and how to resolve this issue. And excuse me if it's not disconnected because I was not following from the beginning.
No, it is absolutely connected, and I agree with you. But okay, again, I cannot know the very particular details of the deal and the documents and what happens. But again, because what I'm discussing here is this idea of data protection by design, it's really up to data controllers, in our case, the university, to look for solutions that respect data protection law. So let me put like a wider policy perspective. Let's say that we make a public tender call for a system in digital education to facilitate hybrid sessions. And in that call, company A says that the price is going to be 50, but they will send the data to third countries. They need the ID numbers of students. At times, you might even see that there are big multinational companies that they're eager to give their services even for free. And if, on the other hand, in this public tender, we have a company that gives a higher price, what I'm saying here is that nowadays, from a policy perspective, we need to start taking those things into consideration. So it doesn't mean always that the lower price is the best option necessarily. And because, again, very often we see big corporations that offer to do the job for free, but it is never for free because they're doing analytics, they are extracting information. So this is a very basic premise of data protection law and data protection by design is that when we are choosing our tools, we need to have these things at the back of our heads. So this is the idea. And I agree with you, even though I don't know how it works particularly in your case.
I think that there is a lot of tolerance regarding who is the data controller to engineer the data protection law in order to be everyone happy according to the GDPR law. That from your lecture, Stratis, I have realized is the only law regarding data protection until this Artificial Intelligence Act will be released by the European Commission. I have another one. We mentioned a lot about the storage limitation, and who is defining this storage limitation, or this data minimization principle. For example, we are doing a lecture. A lot of students, they have their camera off, and this is a digitalization minimization. I suspect we are all happy, but regarding the interaction of the course, this is not so happy. So what are your tips? We should inform the students before the lecture that we would like you to have your cameras on, and please take care to use a blur background, because there are a lot of tricks that you can do in order to be engaged. What are your suggestions on this regarding higher education? I mean, if we inform them beforehand, we are somehow online with these data minimization principles and storage. No, storage limitation, something else. But regarding data minimization principles, are we okay if we inform them before the online lecture how to achieve this?
Oh, very nice question. So
I would like also to introduce you Tatiana Velzer, who is a colleague from University of Maribor.
Nice.
Usually she smiles. Now I don't think so. She's tired now. Now she smiles.
I'm sorry for the delay because of some parallel meetings, and I'm trying to be parallel in so many things as possible, but it's hard. Thank you for announcement, Kostas. I'm smiling again.
Stratis, the floor is yours. Thank you, Tatiana.
Yes. So it's more, so this idea, okay, this point that you make, I don't think it's so much about data minimization. So a characteristic example of data minimization is not ask them to provide data that are just good to have. So, for example, if I don't know, the university registration asks for social insurance number, tax office number, and any kind of data that under the rationale that let's collect them, and in case somebody asks for that, well, this is what data minimization tells you that you shouldn't do. So it's more like, look, just tell me what is necessary for this instance. But you know, the problem is that law, it is a very general piece of legislation, and you have very legalistic expressions like data that it is necessary. What is necessary? You know, this is what lawyers tell you. You need to do a balancing exercise to see how much you need it, whether you can get the job done without it, and so on. When it comes to the cameras of the students, it's not so much data minimization, it's you need to have a legal ground. So you need to tell them why you are recording, to have some general policies, how long you will store them, who will have access, and so on. So for example, do they have access before the exams? Do we keep them after the semester is over? These kind of ideas. And then you need it, sometimes if you say that I use the consent of the student, you need to have them informed and so on. But it's also necessary that you always provide some pieces of information. So it relates to those other safeguards rather than data minimization.
Stratis, regarding this, are there any documents, any templates with specific expressions that you can inform the students why do you record, or it's something that you should inform them beforehand, and in order, if they will participate, they should know the conditions?
I think it need no, so, not I don't think no, it's I'm sure it needs to take place in advance.
Okay.
But it needs to be something brief. It's not like I think when it becomes pages and pages of documents, it becomes it's just something very clear, the reasons why it is recorded. But
yes.
And it's a whole process to draft this kind of documents. It's a process, so to speak, but it needs to be something brief and to be handed out in advance.
Okay, thank you. I suspect some expressions like this one, that when you start the recording in Zoom, they inform you in order to agree or not agree, in order to move away if it is recorded. And we have a comment from my colleague Panagiotis Ignatiadis that said that Artificial Intelligence Act was drafted before generative artificial intelligence models. The European Parliament created, this document without taking into account the generative artificial intelligence models. So So for the first time, European Commission was looking ahead, but not so efficient.
So yeah, that's true. That's true. But what happened recently is that this. Okay. Yes. So
This
yes.
has to do. The second question is like about the ChatGPT, about the copyrights, what the ChatGPT generates. But this was a second question.
So about the copyright questions, it's not so much my field, and it's a whole discussion of its own, and I'm not very prepared for this copyright discussion. One thing is, yeah, but on the AI Act, it was recently approved by the so-called trialogues. So there is an informal procedure where the Commission meets members of the Parliament and the Council. They come together and they approve the text, and then goes through the rest of the process. It is true, it was the draft came out slightly before, but the other idea is that it uses very abstract formulations. So what the European Union does also with the case of GDPR, we see that it doesn't tell us anything specific. It doesn't give us any specific periods. It does not tell us what data are necessary in particular circumstances. They lay down some very broad formulations, which make the life of lawyers and many people very often difficult. But on the other hand, exactly because those texts are very broad, they can capture and readjust in future technological phenomena.
Excellent. It's like, the Greek laws in general, but I think I'm very happy that the same happens in general in European laws. Some generally that a lot of people, they have an opinion and you don't know exactly what is the correct direction. And my final question is the following. You mentioned about storage limitation. Who defines this, the time frame of this storage limitation? And do you define this storage limitation when you inform the students or the participants before any session? So you say to them that the session will be recorded, the session will be uploaded to the YouTube channel for educational purposes, and it will be kept over there for 2-3 years. I mean, who defines? Is the data controller that defines the duration?
Yes, indeed. So it's a policy that you need to have in mind in advance, this storage period, and it needs to be part of the information that the students should receive.
Mm-hmm.
So,
I think that in impact now, we should think about such an expression like a paragraph about the data, like let's say the impact data controller that will define that all the sessions regarding students, they are going to be recorded, they are going to be stored in our YouTube channel, and they are going to be displayed in the public. So the students to know beforehand, not only the students, but any one of the impact participants, that these are the rules.
yeah.
Okay. I have no more questions. I don't know if Elena or Samia or Tatiana, I can see, the people that they are not compliant with the data minimization principles, and they have, the cameras on. On my hand, I would like to thank you, Stratis. Stratis, you are the first lawyer that we have within Athena Talks. We have another lawyer, and with the impact, this is through the impact. We have another lawyer that he will speak on the 7th of June about the law regarding legal and ethical dilemmas of autonomous driving from the University of Maribor, from Faculty of Law, Christian Zahra-Snik. I cannot pronounce the Slovenian surname sometimes. But I think that you, as Stratis mentioned at the beginning, he's a lawyer that is the interface between technology and the law. And I think that what we are doing, here is technology. We should be familiar with the law in order to be compliant. Thank you, Stratis, very much for your contribution. For personally, it was very useful. You answered a lot of questions that I have, and I'm feeling safer now.
The pleasure is all mine.
Thank you all of you for the participation. Until next
Thank
time,
you.
I wish you to have a nice evening and stay safe.
Thank you.
Bye.
Thank you. Thank
Thank
you.
you. Bye.
Bye bye.